Quid Pro Quo Sexual Harassment by Andrew, Christine, Christy, and Austin. Law 2150, Appalachian State University, December 3rd, 2015.
Introduction. Sexual harassment exists prominently throughout businesses today, taking place in many shapes and forms. Sexual harassment is defined as any unwelcome obscenity or sexual advances in the workplace. What is quid pro quo? Quid pro quo harassment occurs when a manager or another authority figure offers or hints that they will give the employee something, such as a raise or promotion, in return of a sexual favor. It also occurs if the authority figure threatens the employee, like with demotion, unless they exchange some sort of sexual act. The difference between quid pro quo and hostile work environment is quid pro quo is the request of sexual favors for an employee contingent upon their employment, while a hostile work environment is different because it occurs when there's many unwanted sexual advances made on an employee.
Trending legal issues. One of the more recent proposals of regulatory action is an act that is attempting to formalize the standards appropriate for determining quid pro quo and hostile environment harassment cases. It would also more clearly define direct liability in these cases. Unfortunately, sexual harassment is currently still trying to be resolved. The Equal Employment Opportunity Commission, EEOC, is holding a public meeting December 7th, 2015, allowing people to hear experts on many harassment topics of discussion. Quid pro quo prima facie. The plaintiff was an employee or worked under the defendant. The defendant made unwanted sexual advances toward the plaintiff or engaged in unwanted verbal or physical conduct. Job benefits were conditioned by words or conduct if the plaintiff agreed to the sexual advances made by the defendant. The decision by the plaintiff directly affected his or her position or future in the company. The plaintiff was harmed and the defendant's conduct is a major factor for the harm. The beginning of quid pro quo cases. In the mid-1970s, courts slowly began to recognize that sexual harassment in the workplace could violate Title VII. Barnes versus Coastal, a case in the D.C. Circuit, is credited with being the first decision to recognize quid pro quo harassment under Title VII. The court concluded that if a woman proved she was fired because she refused to have sexual relationship with her supervisor, she had established actionable discrimination. McMiller v. Metro. McMiller worked for Metro and is claiming quid pro quo sexual harassment against her direct supervisor, Lewis Brown, for sexual acts he demanded of her employment. On several occasions, Brown attempted to put his arms around McMiller and even kissed her on the cheek. Brown then called her into his office and insisted that she remove an ingrown hair on his chin by saying that he could prevent her from being terminated. McMiller refused and headed for the door. Brown then held her back by putting his arms around her and assured her that nothing will happen. The court ruled that there was a link between her refusal of favors and her termination. Byhun v. AT&T Information Systems Incorporated. Byhun was a female employee with AT&T. While there, she experienced multiple acts of sexual harassment from her supervisor, Mr. Fellows. The acts included Mr. Fellows rubbing her leg, asking her numerous times to go out to dinner, and unbuttoning his pants around her. Mr. Fellows told her if she, quote, played her cards right, she could have any job within the company she wanted. Miss Byhun did not agree to have sex with Mr. Fellows, and therefore he began to blackball her within the company. Due to this, she started experiencing depression and anxiety symptoms that caused her to take time off work. When she returned, she had been demoted from her original position and was given no reason for it. There is no room for this kind of activity in the workplace. She was first sexually harassed by a supervisor and then demoted for not complying to Mr. Fellow's wishes. The courts granted Miss Byhun over $3 million for her case.
In the article, Interpersonal Mistreatment in the Workplace, the Interface and Impact of General Incivility and Sexual Harassment, studies have shown that people who have been subjected to sexual harassment in the workplace resulted in them suffering from negative mood, cognitive distraction, and fear, which in turn can lead to long-term effects like depression.
Such as Miss Byhun in the Byhun v. AT&T Information Systems Incorporated case.
In the article, The Strange Career of Quid Pro Quo Sexual Harassment, it states that quid pro quo sexual harassment can take on 4 forms. In the first form, there is proposition, rejection, and retaliation. The second form, the woman complies and does not receive employee benefits. The third form, the woman complies and does receive employee benefit. The optimistic approach would be the woman rejects, receives fair treatment, and is not harassed again by the employer. For the optimistic approach, a claim would most likely not go to court if the woman rejects and receives fair treatment and not harassed again. Also, if the woman complies and does receive employee benefit, she is not likely to bring a claim against the employer since she is benefiting from the favor. The third scholarly article we found was Employer Liability for Hostile Environment Sexual Harassment by a Supervisor. It states that sexual harassment is an extremely problematic issue in the workplace today and has proven to be an issue in the courts today as well. With the possibility of more cases like this appearing in court, the result is likely to be more and more litigation to clarify applicable legal rules in an area in which both practitioners and the courts have long been begging for guidance. In conclusion, quid pro quo is an unacceptable issue that is extremely common in our society today. No one should ever have to feel uncomfortable or suffer emotionally in the workplace due to this type of harassment. Although many states in the United States require mandatory training and education on this topic, some do not. Luckily, in North Carolina, all state agencies are required to develop a plan for illegal harassment in the workplace. These plans also include training for all employees within the company. Our solution to this extreme issue is that all states should require education on sexual harassment to hopefully prevent it in the workforce completely.
This is the first page of our references, and we would just like to thank you so much for viewing our video. We hope you enjoyed, and we hoped you gained a little bit of information on quid pro quo sexual harassment. This is page 2 of our references, and this concludes our project. Once again, thank you so much.